Hello, my name is Michael Tesoro and I prepared this presentation entitled ACCC Cheat Sheet. And the basis for this particular presentation is I was talking to a compliance officer the other day and recommending to him that he sign up for the automatic ACCC emails function. And he said to me that if he did that, he'd be doing nothing else but reading ACCC press releases all day, and that maybe he didn't have the time to do that. So it got me thinking that maybe what might be helpful to various time poor compliance officers to prepare this little presentation summarising what the ACCC has done in the previous month. And the idea would be that I'd release one of these a few days into the following month, summarising what had occurred in the previous month. I thought it was a good idea to go back maybe and start it off in July, so I've got maybe the full financial year covered. So I'll be doing July and then catching up, so that hopefully by early November I'm up to date with recent developments in ACCC activity. The background about myself: I'm a competition and consumer lawyer, and I've been running my practice Tesoro Consulting for the last 15 years, and I help companies, individuals with competition and consumer law matters, investigations, litigation. I also do a bit of consultancy work for some legal publishers on competition and consumer law. Prior to that, I worked at the ACCC in a variety of roles. My last role was director of enforcement, but I also worked as a director in charge of the Sydney Mergers and Asset Sales branch. Now, that one's presentation, I've identified, I guess, 6 topic areas which cover most of the work of the ACCC in July, and I suspect that these are going to be the 6 areas that come up most regularly each month for the ACCC. So courts, well, they'll be looking at court decisions which came down in the relevant month, enforcement actions, and that can be competition, consumer, industry code enforcement actions, mergers, which has been a very active area recently with a lot of mergers being opposed. Guidelines, so ACCC regularly issues guidelines. The big one for July 2023 was the environmentally and sustainability draft guidelines. Scams, so since the establishment of the National Anti-Scam Centre, there's been a lot of activity and information provided by the ACCC about scams. And then inquiries and consultations, which is another very big area of activity. And then I'll finish off with, I guess, what I call other, anything that doesn't really fit into these particular categories. Now, the 3 decisions came down in July, which is probably a bit above the average. First one was Lactalis, which was the first litigated outcome in relation to the Dairy Code. Then there was the Meta Platforms case, which is an interesting case. And the final one was the Phoenix Institute of Australia case. Now, going to the Lactalis case, as I said earlier, it's the first litigated outcome under the Dairy Code, and it's an important case because there hadn't been any judicial consideration of the terms of the Dairy Code. The Dairy Code is a very prescriptive code with a lot of particular obligations which processors have to meet, deadlines, they have to publish things certain ways by certain times. It's very prescriptive. And in this particular case, the ACCC did actually allege 4 breaches of the code, but it was only successful with 2. And the 2 that it succeeded on was, firstly, that Lactalis had failed to publish its standard 4 milk supply agreements in the way prescribed under the legislation, so section 12 subsection 2 of the Dairy Code. So effectively, dairy farmers have to be able to go to the website of the processor and find the milk supply agreement and be able to look at it or download it. But in this particular case, dairy farmers had to contact Lactalis and request a copy of the agreement. So this was clearly in contravention of the obligations under the Dairy Code. The second one was in relation to the terms on which a processor can terminate a dairy farmer's agreement. And it says that you can only terminate it for material breach of the agreement. And what occurred in relation to the Lactalis agreement, they had this additional ground to terminate the agreement if the dairy farmer disparaged Lactalis in any way. So that was considered to be outside what was permissible under the Dairy Code. So 2 pretty obvious breaches of the code, and Lactalis is very big. They might be the biggest processor in Australia, so somewhat surprising that they made these fundamental errors. There were some other breaches that the ACCC alleged that they failed, and probably most interestingly, there was an allegation there was an exclusivity agreement with 90% of the milk had to go to Lactalis, and the court decided that exclusivity effectively meant 100%. So the fact that 90% was reserved for Lactalis didn't breach the legislation. The penalty was also interesting because the penalties for this conduct aren't as high as the rest of the consumer law, the Australian consumer law, and the maximum penalty for this conduct was about 1.2 or 1.3 million, and the judge did impose a penalty of 950,000. The strange thing is that the judge seemed to be in places, this is Derrington, describing the conduct of Lactalis as really not that bad. Some of it wasn't intentional, all the rest of it. And reading the judgment, you would have expected maybe a lower penalty being imposed, but ultimately, penalty towards the higher end was imposed. Having said that, I'm not too sure $950,000 is going to achieve a lot of specific or general deterrence. The second case was, I think, a strange case involving Meta, and it involved the sale of this product called the Lenovo Protect app. And the companies involved in promoting this application were not the parent company Meta, but rather Facebook Israel and Lenovo Incorporated, which is a subsidiary of Meta. And the allegation was that they engaged in conduct which was liable to mislead the public about the nature of the particular application, and also failing to adequately disclose what was going to happen to users' data. And so this product, Lenovo Protect, was being promoted as effectively a way of keeping users' data protected and safe. And they use such expressions as use a free, fast and secure VPN to protect personal information, helps keep you and your data safe. So the implication there is that you could use this particular app and keep your data safe, but in reality what was happening was the data collected through this particular app was being sent to the parent company, then known as Facebook, and used by Facebook to target advertisements for various users and to derive significant commercial benefit. So this case was settled by the ACCC and the two Meta subsidiaries for $20 million. Each of them agreed to a penalty of $10 million. And I don't have great insight into this particular case, but it seemed to me to be a surprising outcome. The conduct seemed to be very blatant, likely to be intentionally misleading, and $20 million seemed like a very low penalty. So I was surprised the ACCC decided to settle this case for only $20 million. Maybe there was something else about the case which meant this was a good outcome, but it seemed to me a surprisingly low penalty for the conduct engaged in. The third case involved the vocational education training provider Phoenix Institute, and this would have been the last case of all the ACCC cases filed against these VET providers, but for the fact the Captain Cook case, which was resolved a few months ago, was actually appealed to the High Court and special leave was granted. So there's a bit more to go in relation to VET cases. I think the appeal to the High Court may be a limited appeal based on the accessorial liability provisions under the relevant legislation. But the Phoenix case was potentially the worst of the lot. It was a very big provider of VET services, and as probably people know, what had occurred was there was a scheme to encourage people to sign up to these VET online courses, and there were a lot of unscrupulous agents running around signing up people, telling them a lot of things that weren't true and offering them free gifts to sign up. So as you can see, the free laptops. And I guess what was happening was the agents weren't taking the relevant steps to assess the language literacy, numeracy, or computer skills of the people signing up. Also, in some cases, people didn't have equipment or even an internet connection, which makes it very hard to do an online course. So it was clearly pretty much a scam going on. Not only the agents were engaging in very unscrupulous conduct, but you had the VET providers who seemed to be aware of what was going on and didn't seem to care. In this particular case, various systems were changed to make it easier to sign people up. So as you can see, the scale of the problem was very, very large. The court found that the vast majority of students had no reasonable prospect of completing the courses, and only 9 of Phoenix's over 11,000 students completed one course, and none of them completed 2 courses. So it's a remarkable failure rate. And the ACCC submitted enormous penalties should be awarded in this particular case, and the judge pretty much accepted those submissions. So she agreed to impose total penalties of $438 million on the two companies, Phoenix and Community Trading Initiatives. And this is by far the biggest penalty awarded under the Australian consumer law. The previous biggest penalty was 150 odd million against another VAT provider. The thing to probably realise here is that Phoenix and effectively all of the VAT providers who got sued by the ACCC previously immediately went into liquidation. So none of the fines were paid by any of the previous VAT providers, and Phoenix won't be paying a red nickel of this fine. So I guess to make a bad pun, I think this is a Phoenix fine against Phoenix, which will never be collected. I think the other thing that's interesting here is it really of much benefit to impose an enormously high fine against a company in liquidation? I think the likelihood of a $438 million penalty against a company liquidation is unlikely to achieve any specific or general deterrence, because everybody takes these particular cases against companies in liquidation with a grain of salt. They don't see it as necessarily a guide to what penalty would be imposed on a real live company. So I question whether this is achieving any real deterrent outcome. Then in terms of enforcement, there was 5 enforcement outcomes reported by the ACCC in July. The first involved secure parking, and this related to its secure a spot promotion, which has been running for many years now. And effectively, you could go online and you could book a spot at one of their parking facilities, and it would be guaranteed to be there. However, what occurred was people would turn up for their spot and it wasn't there, so the spot was not so secure. And interestingly, the ACCC alleged this conduct to continue for 5 years between 2017 to 2022. The ACCC has sued Secure and has sought the range of remedies, including penalty, and it'll be interesting to see if Secure fights the case. The second case involved Bachet Brothers, and the ACCC has been doing a lot of work in the horticulture area in relation to the Horticulture Code. They've been conducting audits and looking at people's websites and asking for their documents. And in this particular case, they discovered that Bachet had failed to make the document which sets out its terms and conditions publicly available to customers. So that's a pretty obvious breach, but really just have to look at the website and see if it's there made publicly available. And they were subject to an infringement notice of $13,750. Then there was a bit of a fail by Costco, which is a bit surprising because they take their compliance very seriously. But they were selling Canadian lobsters as Australian lobsters. So they were saying that the Kirkland Signature previously frozen whole cooked WA lobster or Australian lobster, but it was really from Canada, and they were subject to a infringement notice of $33,000. I guess this is fairly detrimental to WA lobster growers, so I guess there's some detriment that needs to be addressed. This case is quite interesting, Cotton Seeds Distributors, and this is a case where there was no finding that the conduct was actually anti-competitive, but there was a concern the ACCC had that the terms of the agreements with agents may be anti-competitive. So Cotton Seed Distributors obviously sold cotton seeds to various customers, and there was a term in the contract that prohibited agents from applying an insecticide treatment to seed after it had been purchased from the company or assisting agents to do so. So effectively you buy some seeds from CSD and they wouldn't be allowed to apply insecticide. Obviously, if they bought the insecticide from CSD, it'd be okay. So the view was that this particular agreement may be excluding competitors from providing insecticide and forcing customers to buy insecticides from CSD. So they agreed to change their terms and conditions, and it was resolved with the Section 87B undertaking. The final one involves resale price maintenance, Hornet Industries, and that's requiring your retailers to sell products above a certain price. So you can't discount products, you can't sell them below a specified price. And so in this case, it involved recreational vehicles, and Hornet Industries were telling its retailers they were not permitted to sell below a minimum advertised price which it specified. And the interesting thing here is, even though RPM is a serious breach of the legislation, in this case the ACCC resolved it with an 87B undertaking, a court enforceable undertaking, and no penalty. Now, in the mergers area, there are two significant mergers. The first was Australian Clinical Labs uh, proposed acquisition of Helios. I think that's the right way of pronouncing it. And this involved the provision of pathology services. So they described Australian pathology services markets. And the ACCC in its initial statement said that it had significant preliminary competition concerns, which is pretty much code for the fact this merger is not getting through in its current form, and the merger parties better start thinking of divestitures to try and remove our competition concerns. The statement that the ACCC made was that this merger would actually combine two of the top three providers of pathology services in Australia, so 1 and 3, and it would also significantly increase concentration in an already concentrated market. And I remember when I was back at the ACCC in mergers many years ago, we were already concerned about the level of concentration in pathology, so obviously it's become much more concentrated since then. The ACCC said that it had strong concerns about the impact of the merger in particular sections of the market. So they identified community pathology as well as impacts in regional and remote areas. And they also identified the bottom there, veterinary pathology services. So the ACCC is, I guess, signalling to the market and to, I guess, the parties that there are certain areas where there are greater concerns, and that's, I guess, indicating to the parties that divestitures should be looked at in those specific sectors in order to get the merger through. However, the second last point there, that the ACCC was concerned that the merger may result in increased prices or reduced service quality in bid to public hospital tenders, is a harder one to overcome. So obviously when a hospital seeks a tender, they might get maybe 3 tenders in from the 3 largest pathology providers, and the concern is going forward that that might be reduced to 2 tenders. So is that going to result in less competitive pressure between tenderers? And I'm not too sure how that concern can be overcome through divestitures. It seems to go to the heart of the transaction. So we'll have to wait and see whether the ACCC is satisfied with divestitures here or whether the whole deal gets blocked. The other merger is a very interesting one. It involves Coles' proposed acquisition of 2 of Saputo's milk processing plants, one in New South Wales and one in Victoria. And the media was a bit vague as to what the relevant markets are, but I think they're probably state or regional markets for the purchase of raw milk. So effectively, the processors purchase raw milk. And I think a lot of the concern arose from the fact that this is the first time a supermarket, which is a big supplier, one of the biggest suppliers of processed milk, is seeking to buy its own processing facilities. Now that's obviously going to create a lot of concern, having to deal with Coles going forward rather than Saputo. Now the questions that were asked in the ACCC media release was whether the acquisition would give Coles the ability to influence the market in a way that is currently not possible via its current position as a retailer of dairy products and purchaser of raw milk. That's a bit vague, but obviously the ACCC is worried that Coles may have a bigger impact on pricing at the wholesale level. There's also a question of whether or not Saputo would be likely to exit New South Wales after the acquisition, which seems to suggest maybe some sort of failing firm argument. Effectively, if a business is going to fail and the assets it operates are going to exit the market, sometimes the competition laws can be relaxed a bit to allow a competitor to buy the business and keep the assets in the market. So I guess the ACCC will be looking at the likelihood that the company will exit the market and the assets will leave. I think it's highly unlikely that if Saputo did exit the market, the assets would exit the market. So I can't see a failing firm argument getting up in relation to New South Wales. And then finally, whether Coles' increased bargaining power could lead to a reduction of competition at the wholesale level. So obviously, all of the major supermarkets are buying milk from processors, so wholesale purchases of milk. And I guess if Coles is backwardly vertically integrated into processing, then there'll be less competition at the wholesale level. So just using an example, Woolworths might currently buy milk from Saputo, and in the future, if Saputo's 2 processing plants are owned by Coles, there's a high probability Woolworths won't want to buy it from Coles, or maybe Coles doesn't want to sell the milk to Woolworths. So that might reduce the options available to various milk retailers in the wholesale level. I think the other thing that probably the ACCC is concerned about is whether this might be a trend. Maybe the next step would be Woolworths seeking to backwardly integrate into processing, and then maybe Aldi, I don't know, and the whole market changes dramatically overnight. And what are the implications of that for competition? Now, as I said earlier, the big guideline that was issued in July 2023 was the Environmental and Sustainability Draft Guidance. So as you can see, the ACCC issued as a draft guidance and is seeking comments from consumers and businesses on the draft and then to finalise it in the coming months. I think the interesting thing here is the ACCC made environmental claims a priority area about a year ago and didn't have up-to-date guidelines. The guidelines that were in existence were out of date, which seemed a bit surprising to me. I think if you're going to make something a priority area, sort of get your ducks in a row and make sure the guidelines are up to date. But this is a bit overdue, but it's very welcome. As you can see, they want to help businesses to understand how they can comply with the law. It wants to set out some good practice about how to make claims, how to help businesses provide clear, accurate and trustworthy information to consumers about their products. And then they set out the goals of the guidance, and it's a fairly long document, so I encourage you to have a look at it. But in brief terms, they're trying to encourage accuracy by businesses who choose to make environmental and sustainability claims. And what the ACCC said is this is both a consumer protection and a competition issue. So companies that can legitimately make an environmental claim are losing business to other companies who are making bogus claims, and that's really interfering with the competitive dynamics in the market. So they want to stamp that out. They want to demonstrate to business how to make true, clear, evidence-based claims that consumers can understand and trust. So there's no point making a very complicated environmental claim that consumers can't understand, and best not to even go into that direction. Decrease instances of greenwashing, so companies claiming strong green credentials when they don't have them. Assist consumers to make more informed choices. So obviously, if consumers are given better information, they can choose the products which are legitimately green and purchase those, and then companies are rewarded for their investments in this area. Help businesses understand and comply with their obligations under the ACL. So obviously assisting both consumers and businesses, and explain the approach which the ACCC will take to investigating and litigating these type of cases. The interesting thing I find is both ASIC, the Australian Securities Investment Commission, and the ACCC have been very focused on this area, but I think ASIC has probably hit the ground running and taken a lot of enforcement actions in terms of companies making environmental claims as part of their financial representations, also claiming various funds are green or avoid certain types of fossil fuels. And so they've run a number of actions and they've been very active in this area. ACCC is yet to run any big cases. They've run a couple of small ones, but I'm sure they've got a few big ones on their books, which they're investigating. And I think any day now we'll probably hear of a very big case in this area. As I said earlier, the Anti-Scam Centre was set up earlier in the year, and they've regularly announcing different initiatives by that centre. The first was the establishment of a fusion cell, which I had no idea what that was, and it's defined there as a time-limited task force designed to bring together expertise from government and the private sector to take timely action to address specific urgent problems. So set up a fusion cell to deal with a particular scam, get people together from banks, telcos, digital platforms, work out some solutions. Often it's a case of trying to disrupt a scam, and then once effective action has been implemented, probably disband the fusion cell and set up another one. Also, there was an inaugural advisory board meeting of the Scam Centre, and it was interesting because they issued a couple of documents which set out the way they're going to be approaching their tasks. Firstly, there was a number of principles which guide their work, as well as a communique, and those documents are available on the ACCC website. Something the ACCC and the Centre have been doing is putting out scam alerts. So when they become aware of a new scam that's happening in the market, they want to get that information out to consumers as soon as possible so they're alert to the problems. Here was one involving effectively frequent flyer points, and there's Qantas there. They can't seem to stay out of the news at the moment, but it was targeting Qantas, Telstra and Coles loyalty programs, and they're warning people about the scam, but also telling people how it works. So it was driven by a text message or email stating that the consumers' loyalty points were going to expire soon, and encouraged them to very quickly log onto a site, a fake website, which nowadays can look very, very credible and believable. And it prompted the customer to do various things, put credit card details in and all the rest of it. And the purpose of the scam was to try and steal the loyalty points of the customers. So this is a scam that's obviously 200 reports in a short period of time. They want to get the information out there to warn people to be on the lookout for this particular text message or email. In relation to inquiries and consultations, the one that they were asked to do by the government, which I think surprised a lot of people, was in relation to childcare. Seemed to be very much looking at competition and pricing in childcare. Seemed to be a bit outside the normal stuff the ACCC do, but I think it's been shown in the past the ACCC get these requests and they do a tremendous job. They get in there very quickly. They investigate the issues, prepare reports on a timely basis, so they do a very good job. I think they're a lot quicker at doing this than maybe a government department would be. So they issued an interim report on the 5th of July 2023. They made three primary findings. Firstly, that childcare fees have risen in excess of inflation, which is somewhat surprising. It suggests if the market's competitive, it would be charging at or below inflation. Probably not the most remarkable finding that disadvantaged households spend a greater share of their income on childcare than less disadvantaged households. I guess that may result in the government looking at targeted funding programs for disadvantaged people. There are more childcare spots in metropolitan and regional areas, but there's been a decline in family day care and in-home services. So clear movement towards, I guess, certain types of childcare, the childcare centres, as opposed to the family daycare and home care services. And affordability is the number one consideration for families when choosing childcare, but location and quality are not irrelevant. So I guess it's not driven entirely by price. Parents are conscious of, I guess, locational benefits, but importantly, they're shopping around for the better quality providers. So that's important. Customers are fairly sophisticated. I guess it's an important thing where you put your kid for childcare. And they also identified the next step, which is to issue a consultation paper to explore a number of issues in more detail in September. And then the other inquiry and consultation that the ACCC announced was on 10th of July in relation to data broking. And they're looking at the data broking industry, which are organisations which collect information from a range of sources. So you can see there, social media, internet, search apps, customer loyalty card payment providers, public records, etc. They consolidate all that information and then they sell it on to other parties. And the ACCC is looking at two things: how does industry work, how are the relationships set up, and also they want to identify potential competition and consumer issues that arise in the way data brokers operate. And clearly a major focus there will be how they manage private personal information, whether they're disclosing to various groups that they will be taking information and using for other purposes. So that'll be a big focus of that inquiry. And an interesting thing about this inquiry is they've actually identified the various organisations they're going to be looking at primarily, like some other organisations will probably get looked at along the way, but these are the major focus of their inquiry. A few of those I've heard of, a few of them I haven't, but it's in different areas. So you've got Equifax, obviously, in relation to the financial information, debt collection, that sort of area, financial services, and then you've got like PropTrack, which is obviously property information. So these are companies that have been identified as being third-party data brokers. Now, there's one other, which through at the end there, it involves the Australian Energy Market Operator. And it's an interesting one because the AEMO applied for interim authorisation to engage in activities with other electricity industry participants to provide services collectively in relation to the national electricity market. I think it was like maintenance type services. And the argument they put, I think, was that this would generate significant public benefits in terms of efficiency, lower costs, potentially safety. So put a few public benefit arguments that whilst on its face would seem to be anti-competitive, potentially cartel, the public benefits outweigh any detriments. So the ACCC granted interim authorisation, which allows the parties to commence their activities and do it, but that's subject to a final authorisation. And I guess a bit of a spoiler here, like I don't want to ruin people's expectation as to the next instalment, but in October, the ACCC actually denied the authorisation on an ongoing basis. So I'll cover that in more detail when I get to October, but effectively the ACCC didn't believe that the public benefits were going to be greater than the public anti-competitive detriments. So just a bit of commentary. It was a busy month for the ACCC, but I think, they're a very busy organisation, very productive, and so 20 to 30 press releases is probably about right for the ACCC each month. Probably a higher than usual number of judgments. There were 3 in the 1 month. Usually that's probably not that many. And as you can see, there was 2 penalty judgments, but one judgment was like everything in one go, liability and penalty. That was the Novo Meta one. The environmental guidelines was an important thing for most businesses to have a look at. I guess it's important probably for businesses to wait for the final guidelines, like there might be some interest in the draft and wanting to comment on that. But what's most important is when the final guidelines come out to have a good look at those and make sure they're applied in your business. There's been a lot of activity by the ACCC in relation to the Horticulture Code and other codes as well as the Dairy Code in recent times, and it's very simple. They do a lot of auditing, but a lot of it's just to go to various companies' websites and look at the terms of trade, make sure they're accessible, print them and go through them and make sure they comply with all the different provisions of the code. So businesses in those industries had to be very careful. It was interesting the approach that was taken in relation to Hornet RPM. In the past, ACCC would get pretty fired up about RPM and often take legal action, and I don't think it's really necessary in many cases. Most companies engaged in RPM don't understand the law. It's quite remarkable they don't. So I think imposing a penalty, taking someone to court for a breach of the law which they didn't understand is a bit pointless. When I was at the ACCC, I took cases under virtually every provision of Part 4 of the Competition Consumer Act. The only one I never sued anybody under was RPM. I didn't think that it was a really high priority area of activity. So the ACCC seems to be taking a similar view nowadays. RPM cases where there's ignorance resolved with an A7B undertaking. And then the really interesting thing is whether Secure Parking decides to fight the case or tap the mat. I think I might think it has a good argument to defend the case. But I think the main thing with some of these cases is pretty early on whether you got a chance. And so if you're going to give up, I reckon give up straight away. No point filing a case for a year, racking up lots of legal costs, probably getting a larger penalty because you haven't really cooperated. If you're going to give up straight away. You minimise not only the costs but also the management time. So it'd be interesting to see what happens in Secure Parking. That's all I had. Hopefully that's been helpful. I'll seek to catch up in the next few weeks and get these all out, and hopefully I've saved you a bit of time in reading all these various press releases. If you have any questions, feel free to give me a call or send me an email. Bye bye.